Prosecutors in the Charlie Kirk assassination case now urging the judge to finally move the case to trial, requesting that all evidence, including eyewitness testimony, be admitted in a letter to the judge. Here's what they write. This is likely as straightforward a bind-over decision as this court will ever see. After admitting to several friends, including his roommate and romantic partner, that he assassinated Charlie Kirk in front of approximately 3,000 eyewitnesses, defendant surrendered to law enforcement for that crime. The court should bind defendant for trial over on all counts. That's unequivocal. That's direct. Attorney and legal political strategist Katie Zacharia joins me now. Katie, I mean, what is taking the judge so long? What more does this judge need to see?
Well, Todd, good morning. And what they're doing is this is the typical state criminal procedure. Under Utah's Criminal Procedure Code 7B, this is the prosecution must submit a written brief. Then the defense will respond to that. Then the prosecution can respond to that, and then on September 1st, they'll rule whether this goes to trial. Now, as the prosecution said, this is a very straightforward case. The burden of proof is low here. We're in the preliminary stage. It's a reasonable belief that a crime was committed and that the defendant committed that crime. That is a pretty low bar. We have DNA evidence, surveillance, and confessions, Todd. So this is looking very straightforward, though we have to, as you know, get over those procedural benchmarks.
Katie, I understand there are these procedural benchmarks, but I can't imagine that every case in Utah is as protracted and drawn out as this. And I think it's because, and I've said this multiple times, the judge seems to be bending over backward to accommodate the defense at every turn for fear of being overturned on appeal. And at some point, Katie, going for perfect is the enemy of the good. Thoughts?
Well, I actually think that he's doing a favor to the prosecution by ensuring that each step is taken and it's taken well. I would actually I would prefer a longer drawn out preliminary stage so that when we do get to the trial stage and we do have the higher burden of beyond a reasonable doubt, that most of the evidentiary preliminary hearing has been laid out and the judge has the sufficient evidence to bring this to trial. I don't think that he's dragging his feet. I think that this is actually pretty par for the course. The prosecution's 28-page brief lays out a perfect case. We will see that happen after we get to the procedural bearing on September 1st, Todd.
And I think this underscores why you are a very patient lawyer and I was a very impatient lawyer and why I left the law to go do this. Meantime, happening today, horrible story here. Lindsay Clancy's ex-husband expected to take the stand again as her murder trial continues following a one-day recess. To recapture what we did on Tuesday, here's the prosecutor, one day, asking Patrick Clancy about Lindsay's intrusive thoughts. Listen.
And she didn't describe that as hearing this external voice telling her to harm the kids, correct?
Correct.
She told you she was having intrusive thoughts herself of harming the children, correct?
Correct.
And did you ask her how she was going to harm the kids?
I didn't ask it in that way. It was the same thing. I said, do you have a plan and is it disturbing to you? And she said no, and then she said yes.
I mean, this is tough stuff. Such a tricky case. Whereas in the previous case, the evidence is pretty open and shut. You know what helps the prosecution and what helps the defense. It doesn't necessarily here. So in your estimation, which way does that testimony cut to you in favor of the prosecution or the defense? Is it evidence of premeditation, which of course would help the prosecution, or is it really evidence of her deteriorating mental state, which would help the defense?
Yeah, Todd, you nailed it. This is a really tough case. The husband's testimony, in my opinion, goes to her defense. It shows she was a labor and delivery nurse, a mother of 3 kids. There was no history of abuse. And then she was on what is shown 13 psychiatric different medications and a rapid deterioration in the weeks preceding the horrific murder of her children. So there's also another civil case against the doctors for malpractice on the contraindication medications and the drug counter or the drug interactions with each other, the psychiatric meds, I would say that husband's testimony absolutely helps the defense, and you can tell he doesn't really want to do that, but he's really laying out the facts of her mental deterioration, Todd.
And it's important to remember, this is not a defense witness. This is a prosecution witness. To your point, I agree.
Right.
He seems to be helping the defense, and I think that tells you everything you need to know about this case where there clearly are no winners. Katie Zacharia, great insight this morning. We appreciate it.
Be sure to like and subscribe for all the Fox News latest on YouTube and catch full shows streaming now on Fox One.